Thank you, Mike. Thank you. All right. So we'll start at the beginning. So what is jury nullification? And I'm going to talk a little bit about some of the history behind it and how it started and how there's a long common law tradition back to before the colonies and the United Kingdom. But the most important thing that I want everybody to get, the money quote or the money point here, is that once a jury goes back to the deliberation room, it can do anything it wants. It doesn't matter what the judge told you. It doesn't matter what the DA told you or even what the defense counsel said or the two lawyers in a civil case. It is completely private what goes on in that jury room. A juror can do anything you want to do. Now, hopefully you'll be within the bounds of your individual conscience. And that's the overall point of what jury nullification is that an individual's conscience cannot be overruled by a judge or by something the legislature did and passing a law. You are not bound to that once you go into that jury room. You are only bound by your individual conscience. And there's lots of history behind it. And I think one of the things that really gets judges and DAs in particular upset about it is that it's a lack of control. They can't control the jury. If you can go back there and do whatever you want, if you're not going to listen to them and say, if they tell you you have to do X, Y, and Z, if you find A, B, and C, if you don't do that, they've lost control. And I submit that that's rarely going to happen. Jury nullification is rarely going to happen. Most cases are going to involve an assault, a theft. Who's going to nullify that? It's not going to happen. And to me, I'm sure we can come up with some scenario where it might, but as a regular routine basis, as a rule, that type of thing is not going to happen. Now, got to give credit to the Fully Informed Jury Association, FIJA. If you haven't gone to their website, I highly recommend it. It's fija.org. And they've got lots of good information, lots of good resources there. And so I'll read you their purpose. I think it gives a good foundation, a good starting point, a good baseline for what jury nullification is, because it's why they exist. So the FIJA purpose, their mission, is to educate Americans regarding their full powers as jurors, including their ability to rely on personal conscience to judge the merits of the law and its application, and to nullify bad law when necessary for justice in finding for the defendant. And it goes on, this includes the option to conscientiously acquit when a just verdict requires it by voting not guilty, even if you, the juror, believe the law has technically been broken without fear of punishment for their verdict. You can't be punished for your verdict. Not in the United States. Not yet. And you can't be punished for your verdict. Now, there's some cases that you can read about back in England that there was a case involving defaming somebody in the government, like one of the lords or barons or whatever. And the guy was guilty. He said it. He was in violation of that law. And the jury was like, so what? Yeah, he's in violation of the law, but we don't want to punish this guy for that. We don't care what the law is. And they acquitted him. And in that case, the judge, who was part of the aristocracy, actually put the jury in jail and made him come back and do it again. They still acquitted. And eventually, some other guy came along and let them all out. That can't happen anymore. So don't worry about that. They can't put you in jail now, no matter what you do. And in some examples of when it might happen, like today, have anybody read the book Molin Labe by Boston Tea Party? It's not his real name, but that's what he writes under. Yeah, I know. It's hard to believe. Well, there's a good example in there of a jury nullification that could actually happen. The ATF enforces all kinds of gun rules. And, I don't know a lot about guns, but I know that when you fire a weapon, it has a flare, puts out a certain amount of light when you fire it. Well, in the book Molin Labe, there was a guy up in Wyoming who had a firearm. The firearm itself was legal, but the amount of flare, well, if you had a flare suppressor on it, I think that's what you call it. Flash, thank you. Thank you very much. A flash suppressor on it. And it was just underneath the legal requirement. He suppressed it too much. That's the kind of law that a jury said, yes, he violated that law, but that's so stupid, we're going to acquit. So that's a good example of what types of thing that can happen. Now, two things are decided in a legal case, on any case. That's the facts, and it's what law should apply. The province of the jury is, in essence, what everybody knows and what you were told, is you get to decide the facts. Did the defendant fire the weapon? Was the red light, or was the traffic light red? Did so-and-so die as a result of getting beat up? Those are factual issues. So the jury hears from both sides and determines which facts are true or not, or which facts are more likely to be true in a civil case, or which facts are, they believe, beyond a reasonable doubt in a criminal case. That's the standard duty of a jury. I think most people get that. But what you can also do, is what we're talking about, is if in a given case you think the law, even though it's been violated by the letter, if you think it's unjust, either an unjust law in general, or it's unjust in the application to the case you are hearing, you can vote for an acquittal anyway. Now, to get a conviction, you have to have a unanimous jury. You don't have to, and to get an acquittal, to get not guilty, you have to have a unanimous jury as well, in Colorado anyway. But one juror can prevent the conviction. So it only takes one person to say, no, I am not going to apply the law to this case. So you can't get a conviction. If it's 11-1, you can't get a conviction. So that's where the conscience, I think, comes in to play. And so one single juror has a lot of power. Now, the DA or the state can decide to retry the case, but they'll have to. It's not a conviction at that point. For the most part, the legislature passes the laws. And so we've got the facts. Jurors get to decide that. Nobody ever questions that. For the most part, the legislature writes the laws, writes the criminal laws in particular. And there's no such thing as a common law crime in the United States. It has to be a statute that lays out the elements. If you do A, B, and C, you're guilty of X. And the legislature passes those. So the legislature says, here's this law. The judge will also determine which specific part of the code that the legislature has passed is going to be applied in this given case. And so you've got the law from the legislature, you got the judge deciding which part of the law is applicable, if there's any dispute about that. Sometimes there is, sometimes there's not. And then the judge always gives jury instructions to the jury. And as we talked about, it's a de facto power. No matter what you're told, you've got the power to follow your conscience back in the jury room. Well, the judge isn't going to tell you that. The DA is not going to tell you that. The defense attorney can't tell you that. If the defense attorney wants to argue, yeah, you know what? He did it. But in this case, it's not just to convict him because of whatever reason. You know, the flash suppressor or whatever it might be. Scott?
Why can't the defense attorney say that?
Because you'll get disbarred.
Why?
Because the judge, you don't necessarily get disbarred the first time, but if you do it enough, you'll get disbarred. You can be held in contempt if you make that argument. They can put you in jail for that or fine you or whatever. It's about control. The judge wants the jury to do what they're told, what he tells them to do, or she. The DA wants the judge to do that. The DA wants the jury to only do what they are told in his argument.
And it sounds like the Bar Association wants the same thing.
Absolutely. You're right. The Bar Association does. That's the way things are right now.
Who's not in contempt when they're in court?
Who's not in contempt when they're in court?
Yeah.
Most people are in contempt. But it's a legal standard there. I know what you're meaning. Yes, sir.
So I have a question.
Yep.
It's kind of a newer concept to me. I've heard of it, but I'm not familiar with the process. So if I'm a juror, I have essentially two options. One, if I feel that the person's not guilty, or let's say I feel like they're guilty, but this is really unfair.
Right.
I could potentially say I'm going to rent. My vote's going to be it's not guilty, or I can convince my fellow jurors. So option one, I'm the one person that says not guilty. They can potentially retry that case.
Yes.
But if, on the other hand, I convince my fellow jurors that, you know what, he's guilty of the letter, but not the spirit of the law, or, we think this is an unfair law, we can vote not guilty, and if we all render not guilty, then they can't retry the case. And that's an example of jury nullification there. Do you have to say, we're nullifying this verdict? Or
No.
You just say not guilty?
Correct. The only thing you're going to be asked to decide on that jury form is, there may be a couple of preliminary things, but at the bottom, the important part is guilty or not guilty.
Okay.
And that's all you're going to check is not guilty. You don't have to write in because we believe this is an unfair law.
All right.
I wouldn't recommend doing that. Just do not guilty on it. And I'm sure a lot of y'all have read A Time to Kill, the Grisham book.
So I would say
that's another example. Yeah,
there's not really a way to then track to see how many times jury nullification has been used because they don't necessarily label it as such.
That's correct. It's not labeled, but it's generally not too hard to know when it happens. But it does require some analysis. It's not just they all agreed that they were nullifying the law. That won't happen. It won't be that clear. But usually you can look at it and figure it out. Like the case where the libel cases from before the colonies took over back in the UK, the common law was truth was not a defense. So you could tell the truth and you could still be held guilty or be held responsible for libel or even criminal libel because the king and the sovereign didn't want bad things said about him. The fact that it was true didn't matter. But so the jury, if the case is obvious, if the guy said it, and the jury then goes, well, we're still not going to convict, you can look at that and kind of figure out that's what they did. Yes?
David, what about Colorado's death penalty phases where they have to then go through all the different steps to determine whether the death penalty will be issued? In the Aurora trial, Brockler was very disappointed, but it really just took one juror, and they now say maybe it was two.
They say three at this point.
And just say, no, we don't want to put this person to death. Is that a form of nullification because their conscience wouldn't let them kill this guy?
I don't be technical on this. In a death penalty case, there are several levels. You're right. First, you got to be found guilty. Then you got to find that there were some certain aggravating factors.
Aggravating and then not enough mitigating.
Right. Not enough, the aggravating outweigh the mitigating. Right. And then you still have to decide whether or not you want to kill the guy, execute the guy. Y'all might have heard me in the past. I'm against the death penalty, but that's another issue. I'll just say quickly that as a limited government believer, I find it completely inconsistent to say I want to give the government the power to decide who they're going to kill. That's not limited government, but that's another topic. And I guess Stacy was here talking about that not long ago either. All right, so jurors. Let me talk about the death penalty and how those jurors, how that process works. During the jury selection process, and this is important for every case, each side has a certain number of what they call peremptory challenges. You don't have to have a reason. If you just get a bad vibe from a juror and you don't think he's going to be favorable to your client, you have a certain number of those. You can kick them out. Then there are challenges for cause. In a death penalty case, if a juror says, or potential juror says, I don't believe in the death penalty under any circumstances, that person will be excused for cause.
Right.
Exactly. It's called, you have to death qualify the jury. And that's because it goes right to nullification. Because you are going to be told that the death penalty is potentially on the table here, or is on the table, and you might potentially have to decide that. And so you are going to have to agree that you can apply that law given the facts of that case. So if you can't do that, and a lot of people can't. I mean, they would know if they looked up anything, they would know that I am against it, and they would kick me off for cause.
That's the easiest way out of 12 weeks off your job.
Right. Now, and I'm not ever going to advise anybody to mislead the judge or jury, and there's ways you can try to just say as little as possible if you want to get on a jury, because I think it's important to do it if you can. So in the death penalty case down in Arapahoe County with the shooter, that necessarily wasn't a jury nullification case, because the jury has to decide if they think, based on everything they've heard, whether or not the death penalty is appropriate. And there are already people that the DA is convinced would apply the death penalty in some case. They're not philosophically opposed to it. And they apply that, and they go, no, in this case, I can't apply it. And I think the three, or at least the one that spoke about it in that case, said he was too mentally ill for me to feel good about killing him or having him executed.
The answer that they all gave.
Right. But that's part of the process. I wouldn't call that nullification.
But what I found interesting was that during the mitigating factor portion of that phase, mental illness is a mitigating factor. Well, they didn't find it at that point. They all agreed, 12-0, that would go forward. It wasn't enough. And then it became enough when it came to the final vote.
Yeah, and what we're talking about here is that you're right, that in order to get that far along the process, the jury had to decide unanimously that he wasn't legally insane. See, and so they all agreed he was not legally insane. If he was legally insane, he wouldn't be guilty.
Yeah.
So they did.
Well, they had the option in the very first verdict, right, to say he was
insane,
right, and not guilty, but
correct. And the 12 of them said no, we're not going to find him not guilty. But it's a different standard when they get to the death penalty part. They can all go, yeah, well, he's guilty. He knew what he was doing.
We all knew he was mentally ill, but not criminally insane.
And that's what happened. Yeah, I mean, that's basically what happened. So I'm just saying that it's not inconsistent to say he wasn't legally insane, but I think his insanity or his mental illness makes it unjust to execute him.
But that's step one, though, the whole insane thing. Then there's the aggravating circumstances, and they agreed on that. Then there's the mitigating, and you would have thought if they would have thought he was too mentally ill, that would have been the mitigating, and it would have been a dead stop there because it's the same one juror only needed to stop the process.
Right. Yeah, I mean, it could have stopped there, right? But I don't think it's inconsistent what they did. I mean, there are several levels. Yeah, right, exactly. Here's a legal case. Yeah, please.
From what you said before, there's nothing that obligates any juror, much less the entire jury, to be consistent.
That's correct. I'm just saying in that case, I don't think they were inconsistent. But you're right, they don't have to be consistent. No. There are other cases where, particularly in a civil case, you can have an inconsistent verdict where they found something here and something here that don't work, and that can be the basis for the judge to grant a trial or even to ignore it. But that's kind of a separate issue. Back there?
Yeah, this is back on the judge's instructions. I was reading up on this, getting ready to go to the county courthouse, and I thought I read something that said until 1890s, or there was an 1895 Supreme Court case that said the judge did not have to tell the jury that they got to judge both the facts and the law. So I presume that until the 1890s, it was a tradition that the judge did instruct the juries that it was their job to judge both the facts and the law. So I'd like some clarification on that.
Yeah, so the question is, there was a Supreme Court case, I believe it was the Supreme Court, U.S. Supreme Court, that said, sure, the jury can do whatever they want, but the judge doesn't have to tell them that. And at some point, so that kind of asked the question, so at some point, did they always tell them that? And I don't have that history 100% down, but I don't believe they did. I think some judges would and some judges wouldn't. And then what happened in that case was the defendant said, I want the judge to tell the jury that they can judge the law too. And even if my guy's technically guilty of all these things, they can still say not guilty. That judge said, no, I'm not going to tell them that. So that's how that got up to the Supreme Court, because the defendant lost and said the judge should tell everybody that you can nullify, in essence. Another way to look at nullification is a veto. It's a jury veto. And that may be even a better way to look at it, because I think people can grasp the concept of a veto a little better. You're like, in this case, I know what the law says. This guy violated that law, but I or the jury and together, we're going to veto that law in the application here.
Just a comment. Just to show how off the rails we are, I was talking to an FBI agent when I told him that the jury has the right to judge the law and the facts. He said, no, they don't. He said, flat, no, they don't.
Right. Well, yeah, and a lot of them will say that.
So that's the trouble we're in.
Yeah, and they're wrong. But again, he can say that all day long, and the judge will tell you can't do that. I mean, he won't say you can't do it, but he'll say you have to do what I tell you. All right. But that goes back to the de facto part of this. There's nothing anybody can do to you if you go back there and you use your conscience and decide to vote not guilty. So they can tell you, no, you can't. But it's kind of like, well, even if that's right, what are you going to do about it? Nothing. They can't do a thing about it. So that's where we are today, where people aren't told about this, and the judge will tell the jury that they have to do what they're told, and the defense can't make the argument about nullification. So the jury can't be told specific, and that's why this type of thing is important. That's why the people handing out the flyers is important, so people do know. Yes, sir.
But I recall that there were always some sort of questions that said, are you willing and able to judge on the facts of this case and hold you up to perjury if you actually acted as a jury nullifier?
I have never. It's going to be impossible to prove that a juror committed perjury. I mean, I'm sure we can come up with some way that they committed perjury. That's why I said earlier, don't lie. Don't lie. Tell them you'll do your best to apply the law, or you do your best. Or if they ask you, do you believe in jury nullification? And you do, say yes. Then they'll kick you off. But that's all you can do. So don't lie. But you don't have to lie to do jury nullification. You don't have to, because they rarely get to it. And when you're asked a question, if you're ever on the jury and they're doing the selection called voir dire, they ask you a question, and I tell this to all clients in a deposition or if they're on the stand, listen to the question, take a second, make sure you understand the question, answer it, and shut the hell up. Don't say anything else. If they want to ask you more questions, follow-ups, they will. And here's the kind of a trick question I ask people. Justin, can you tell me what time it is? The answer is yes. Right. Most people will tell you the time. See, it's a trick question, but it makes people think through the process. What was I asked? Answer that question and shut up. People think that people want to be social. People want to fill the silence because you're in a social situation. That's what most of us do. But that's not the rule when you're testifying. I don't care if they take 8 minutes for somebody to ask you another question. It's not your job to fill that silence. And it's the same thing for jury selection voir dire. If you get up there and say, I don't believe that the jury has to do what we're told, it's up to us to apply the law according to our conscience, not what the judge tells us, you're going to get kicked off of the jury. So if you want to get on, you don't say that. But if it comes down to, if you're asked directly, do you believe in jury nullification or something to that effect, that's when you realize you're going to be kicked off. Don't lie. Don't ever mislead them. But you can say then something that the rest of everybody else is going to hear. Then you make your quick little comment about it is a long-standing tradition in American jurisprudence that the jury can judge the law as well as the facts and nullify any law that they do not feel is just. All right, well, they're going to kick you off, but everybody just heard you. And there's nothing wrong with that at all. Or something to that effect. Justin.
So what is preventing the defense from talking about it? Is it just losing their job? Is it illegal?
Yeah, well,
to get thrown in jail if they do this?
It's not a crime for the defense to try to make that argument, but the judge can hold you in contempt of court for doing it. And usually it takes more than once. Usually the judge would go, come up here, approach the bench. Don't you talk about jury nullification, or don't even insinuate jury nullification, or I'm going to hold you in contempt. Then you go out, then you do it again. Bailiff, take this man away.
So is there rules written somewhere that they can't do that? This is just up to the judge's discretion to do that to you?
Well, the rule is that the judge instructs the jury on the law, and the jury has to abide by what the judge tells them. That's the rule. That's the rule as it's given. And if you try to subvert that by informing the jury of what they actually can do, right, the judge can hold you in contempt.
The judge has the discretion to say, fine, you're out of here.
Yeah, absolutely. Judge controls the courtroom.
By the same token, if you wore a wig to court that day, he could also say, I don't like what you're wearing, get out of here. Can he do that? Does he have that much discretion?
Yeah. Yeah. Right. Exactly. Like a hat. Exactly.
Real?
Yes.
Cell phone.
Yeah. Oh yeah. Or if your cell phone goes off, that type of thing. If your cell phone goes off, any number of things. All right. Here's a little history on how far this goes back to our foundational principles. This is a quote from John Adams. It is not only his right, but his duty to find the verdict according to his own best understanding, judgment, and conscience, though in direct opposition to the direction of the court. So that's John Adams, second president, one of the founding fathers. So this is not a new concept. And there's other cases. There's a case even from 1969 where, again, I think this goes to the de facto power here. Even though it's against the law or against what you're told to do, you can do whatever you want back there. And I think that the courts recognize that. This is a 1969 case, a federal court of appeals case. If the jury feels the law is unjust, we, meaning this court of appeals, recognize the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by a judge and contrary to the evidence. If the jury feels that the law under which the defendant is accused is unjust, or that exigent circumstances justified the actions of the accused, or for any reason which appeals to their logic or passion, the jury has the power to acquit, and the courts must abide by that decision. Because if there's acquittal, the state can't do anything about it.
Is that a case then where someone brought an appeal to the appellate level?
Yeah.
And then they felt that it was a nullification, and then they made that ruling?
Yes, and I don't know the exact facts.
That's interesting.
I didn't read this whole case. I got that quote out of a FIJA thing, but I have the site. For the record, United States v. Moylan, 417 F. 2nd, 1006, 1969. And there was a state that passed a law that said a defendant can argue for nullification. That was New Hampshire. That was just like 6 or 7 years ago. Live free or die, right? New Hampshire. Well, the New Hampshire Supreme Court said that doesn't really mean that. Yeah. So the legislature passed a law saying, now the statute didn't say the judge had to instruct the jury about it, but it said the defense could argue it if they wanted to. Could let the jury know that you guys can do whatever you want when you go back there, and if you feel like this is not just, you can vote, you can acquit. So that was a good try. The Supreme Court of that state struck that down, and I think New Hampshire is going to try to overcome that again. But so that did happen. And then I'm sure all of you are familiar with the Denver case that's going on now. There are some people handing out jury nullification pamphlets, probably just like this one from FIJA, the Fully Informed Jury Association. And they were arrested and charged, there's 2 of them, were charged with 7 counts of jury tampering, which are felonies. They got to 7 because apparently, they handed out a bunch of them, but apparently they got to 7 jurors. So that's how they got that. So 7 felony counts. Now, this is the United States of America. Somebody is giving somebody else a piece of paper and says, read this, and that's a felony, or at least they've been charged with a felony. That's Democratic DA. Morrissey. Mitch Morrissey.
It actually had to do with the case. It was specific to the case, and they're leaking media reports to them or something like that.
Right.
This is very general.
Right, exactly. And that's their defense, because the statute, which I brought it with me, I can read the statute, but the statute requires the intent to influence a jury's, or jurors, just be one juror's decision in a specific case. So you have to say, you're a juror on this case, I want you to do this. That's jury tampering. That's not what they did. They're handing documents out to everybody. And shortly thereafter, David Lane, representative, filed a Denver judge said, I'm banning all handing out of literature out in front of the courthouse. Right. Oh, absolutely, he did. And so David Lane went to federal court, and like within a day or 2, the federal judge said, you guys can't do that. You guys can't do that. So they stopped doing that, and then within another couple of days, or some short time period, some people were handing pamphlets out. And actually, I was there last week, and people were handing stuff out. I told them to keep up the good work. Some people were arrested again, and all their stuff was seized. Now, the justification that the police department gave was that they were obstructing the walkway, that they were in the way of people just trying to come and go. So that's probably a pretext But since then, they're out there, like I said, as far as I know, they're still out there every day, or somebody is, handing this stuff out. Scott?
I was just going to ask how that would be any different if you were on the radio that day and jurors were listening to you on their way into court. How would that be any different than someone handing out pamphlets?
I would say it's not. I would say it's exactly the same thing. Exactly the same thing.
If you're obstructing the airwaves.
Right. Obstructing the airwaves.
Just for a
Yep.
conclusion on that topic,
Yeah.
I thought that the police chief had told his officers to quit arresting them. I thought I had read that. Maybe that wasn't Denver, but
At some point,
was.
at some point, I think he did. I don't know the exact timeline, but I think once the federal court said you can't do it anymore, they stopped doing it.
so these things keep on flaring up. Like
Yeah.
people forget about it for a while, and they go out there and they hand out the literature, and the police chief hasn't come across this before, so the goons arrest him, and
Yeah.
then we have to go to the federal court again, and the federal court puts his foot down, and
you know,
this happens every
yeah.
3 years, I'm sure.
Well, this is the first time I've heard about this. I mean, actually happening, or somebody getting arrested for handing out pamphlets. I mean, I'm sure it has happened.
Maybe here, but I know
Yeah,
it's happened
I'm sure
in
it's
other
happened.
states.
Yeah. Yeah. And let me also, I'll close, and we can take questions, but this is, I think, was a great statement from FIJA. And it comes with it. You can get a color poster if you want. And it says, and I think this is powerful. The biggest and most powerful law enforcement agency in the United States has the absolute non-negotiable power to ignore laws, judges, and prosecutors, to keep people out of prison, to make any jury trial come out the way they want it, and to make our government honest. Who is this agency? The fully informed jury. So I think that sums it up. It's a great little saying on that. And yeah, take any questions. Thank you.